Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Sinas from Sinas Dramis Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Takura Nyamfukudza from Chartier Nyamfukudza, PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people with real legal problems. Today's episode, we're going to talk about criminal liability surrounding the Oxford High School shooting, tips for parents who are going to court for their family law cases, and the rights of senior citizens with respect to the new auto insurance laws. Stay tuned for a great episode.
In the name of criminal defense.
The tragedy of the Oxford High School shootings has left this country reeling. In the wake of charging the suspect with multiple counts of murder, prosecutors have now brought charges against his parents for involuntary manslaughter. Today we have with us experienced criminal defense attorneys, Mary Chartier and Takura Nyamfukudza of the law firm Chartier and Nyamfukudza. Welcome back.
Thank you, Lisa.
Thank you.
So how did the charges against the parents for involuntary manslaughter differ from the charges that they have brought against the child who was the shooter?
The main difference, Lisa, is that the 15-year-old was charged with first-degree murder. And the basis of that is he intended to kill his classmates and others at the school. For the parents were charged with 4 counts of involuntary manslaughter. And I pulled the jury instructions to go over them a bit today because there's a big difference. For the parents, there doesn't have to be, for a conviction, an intent to kill or an intent to injure. There's a line of cases it's a kind of an older line of cases where if a misdemeanor was committed or another criminal act, there has to be an intent to injure, and then that can form the basis of the involuntary manslaughter. But the likely theory here for the prosecutor will be gross negligence. And for that, the prosecutor will need to prove that each parent caused the death of, and then one of the individuals for each count, and that person died as the result of what the prosecutor is claiming to be the gross negligence. One of the things that has come out, or at least the allegations at the press conference, was that the parents didn't lock up the gun. Although we heard at the arraignment, the parents' lawyers say that's absolutely false, that the gun was locked up and the 15-year-old got the gun. We don't know how. But so that's likely to be a very big point of dispute. But if we believe that the prosecutor is going to proceed on that grounds, then that could be, for example, the basis, that's the gross negligence by not locking up the gun. But that's not where this ends. Then the prosecutor needs to show that the gross negligence is more than just carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. And the jury would need to find each parent beyond a reasonable doubt guilty for each young person who was killed, and then that the parent knew of the danger to another, knew there was a situation that required him or her to take ordinary care to avoid injuring another, and that the parent could have avoided injuring another person by using ordinary care. And that when the parent failed to use ordinary care to prevent injuring another, when to a reasonable person, it must have been apparent that the result was likely to be serious injury. And this is really fact specific, and it's going to essentially go on what the parents knew. And if I were defending, the parents, I would point out that the school had information and shared it with the parents, and then the school let the young person remain at the school for the day. I mean, I don't think there's anybody at the school, for example, who thought that there were going to be these murders, but what the school knew and what the parents knew is going to really intersect on this gross negligence allegation that's likely to be the main theory for the prosecutor.
So is it unusual for charges to be brought against parents for involuntary manslaughter in a situation like this?
Oh, very much so. And if I may add to Mary's answer very briefly, I think another big difference is that the son could draw his last breath, will draw his last breath behind bars if the prosecutor proves each of the charges for the first degree. And the penalty is steep for the parents, but not the same as for the son. But yes, this sort of derivative charge is unusual because we normally see this when, for example, the other people who have been charged, say, went along in the car or, but as long as defense counsel can prove that it is more tenuous than the prosecution is alleging that it is, then they stand a chance. But this has even made news across the pond, as people would say. I've heard from my family members in England about this story. So the world is watching, literally.
What's interesting too is where involuntary manslaughter charges have been alleged against parents when there's been shooting is when there's been, in general, a very young child. So for example, a 6-year-old who, got access to a gun and committed a shooting. And there, the negligence, I think, or gross negligence is quite a bit different than what they're alleging in this situation. I mean, this isn't a young child who doesn't understand the ramifications of what a gun can do. This is someone who intentionally planned to murder his classmates. It appears that that's the case.
So why do you think the prosecutor brought these charges for this case?
I mean, you see the press conferences that were, in play, even while the defense lawyers were trying to arrange to turn their clients in. So, there's definitely a very large media component to this. I think the prosecutor, if we look at, are there good intentions here? Of course, right? Everybody wants to ensure this never happens again. This is a situation where the family is affected, and it's not just the families who lost their loved ones. It's every family and everybody at that school, every parent who in that morning thought, the most, exciting thing that's going to happen today is, will I get to work on time, or what am I going to make for dinner? And then unfortunately has that time period where they're wondering, is their child even alive after going to school? I mean, the devastation to the community and to parents and children everywhere, it just can't be minimized. But I think the goal is to stop this from ever happening again. But I don't think that's going to be achieved, honestly, by charging, and even if they convict the parents, and I think it's going to be an uphill battle to convict them. Because I think if the Crumbleys believed that they could be charged with involuntary manslaughter, I doubt they would have done anything different. I think they didn't believe their son was going to commit murder that day. And it sounds like nobody else did either, despite that there appears to have been at least rumors going around the school that could have happened among the young people.
So the court set the bond at $500,000 per parent. Is that a high or low amount? Help give us some context.
It's high. I think Takura and I have had murder cases where the client has had, not had a bond that high. We've had murder cases where the client has had a bond even higher. But I think for two people who have relatively minimal criminal histories, it is a very high bond. It sends a very clear message. It would be incredibly difficult for anybody to come up with the money for that. But I think the big thing here was the allegation that, they were hiding and they were, they were in a basement. And again, you heard during the arraignment, they are represented by two very zealous criminal defense lawyers who Takura and I know very well. And they said that narrative of them not wanting to turn themselves in is just not true. And, Takura and I have arranged a lot of walk-ins for clients, and there is an arrangement that you make to turn them in. And it's not, it's certainly not, hidden to us that the prosecutor, announced the charges on a Friday. So that would mean that even if they could try and come up with the money to get a bail bonds person, that's not going to be happening on Friday. They're going to be spending the weekend in jail. And that's the sort of gamesmanship that I think, even in a case that's so tragic like this, we still see playing out by the prosecutor. This is a tragedy from start to finish. And it's just, even if there are convictions, the community will never be the same, and the families won't either. It's really heartbreaking. We explore these issues and more on our podcast. And again, everybody's hearts go out to the family and the community here.
Do you think other charges will be coming down, Takura?
Possibly. There's talk about school officials being charged because they didn't move and act on the drawings and other things that, if are true, they learned about before this tragedy happened.
Well, we're certainly going to be following this case for quite a while, I predict. So thank you for your time today.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC. in the name of family law.
Good morning. I'm here with Kent Wood, who's the owner and lead attorney at Wood Associates. That's a firm in Lansing that specializes in family law. Welcome back, Kent.
Oh, thank you.
So, what is your approach when a new client walks into your office with a family law case?
Well, when a new client walks in, we like to kind of get to kind of our process, our, philosophy. I often tell clients that we strive to protect your best interest from its three greatest enemies: others, the government, and your emotions. And kind of to drive home that point that there's a lot of things that are affecting your decisions that are outside of your control. And when we talk about others, we're usually talking about the spouse, significant other, whoever we had a child with. When we're talking about the government, it could be the court we're referring to, it could be Child Protective Services, it could even be school, right? And then when we talk about your own emotions, we're just talking about all the anger, frustration, anxiety related to this kind of, a lot of people first time ever in courts experience. And we try to address this by educating clients about the whole process and about how to really approach dealing with the other side. In these relationships, there's a point where there's trust, right? And then something happens and the trust breaks, and now you've got to work with someone you don't trust to raise a child in some point. And sometimes we refer to this as a battle or as a war, and it comes down to what I always call a battle of reasonableness. You have to be reasonable. When we talk about emotions, I tell my children, you can't control your emotions, but you can control your actions and your responses to other people's actions. And so that's what we focus on. What can we control? And there's a lot of times, for example, someone doesn't show up for parenting time, right? You miss Thanksgiving, or you're supposed to have a phone call with somebody and it doesn't happen and they fall apart. I always say, well, what's the reasonable response? Is there something reasonable to do that? You can't yell at that person. That's not going to change anything. We also talk about how you had a relationship, somehow had a child with somebody, and that person could have been, let's say it could be a jerk, disrespectful, lying. Just because you're in a court battle, all of a sudden, they're not going to stop being that way. And so we try to prepare everybody to understand how they should be reacting to all of these things, and that's what we focus on. We focus on our clients' needs.
So it sounds like it's great when both sides are being reasonable. How often does that happen?
Well, that's rarely. Unfortunately, a lot of people come in thinking it's going to be reasonable to start, we're going to get along, and then the lack of trust that was there kind of flares back up, and then it kind of breaks down and becomes argumentative and contentious.
So, how do we get the people out of this situation? How do we get both sides to be reasonable?
Well, the good thing about the court process is you end up with an order, and everybody has to follow that order. They're not going to always follow that order, right? People are human. They're going to, their own emotions, just like your emotions, are going to dictate some decisions they make. So remember, always be reasonable. You can always enforce the order. And I try to have clients focus on, you can't stop somebody from being disrespectful, but you can ask them to follow an agreement that they've either agreed to put in place by consent, or the court has decided this is what the rules of the game are going to be, and to stick to that.
Well, let's talk about consent orders. So, and getting parties to settle their cases so they don't have to go through the whole court process.
Right. So a consent order is the idea that we have major issues, and usually it's custody, parenting time, support, and division of property. But specifically with custody and parenting time, it's always best if you can consent, because it's a schedule that works for everybody's schedule. Because even as when you're together, you're raising kids, but you're living a life and work and all that outside of that. When you're separate now, you're raising kids separately, but you still want to live a life and everything outside of that. So a consent order allows the parties to put together, craft something that's unique to them, where they get to truly decide what's going to work for their schedules. As opposed to where the court orders it something, and there's usually just set things in place that the court orders. They have standard parenting time schedules in a lot of counties.
So when parties can settle or mediate and come to an agreement together, maybe neither of them love it, but it's something they can live with. Then let's talk about what happens when the judge decides who's going to have custody or what the parenting time schedule is.
Well, when it comes to the judge deciding, I always kind of warn clients that, look, you lived with this person. You know this other person intimately. The judge is kind of coming in, and it's a snapshot look of what's going on. He doesn't know every little detail. He's not going to know. When I say he, it could be a female judge as well, but they're just not going to know. And so they're making decisions based on this summarized, idealized version of what's going on, and trying to see through who's been credible. who's been, or I like
Who
to
do
tell
they
myself-
believe?
Right, who do they believe, who's been the most reasonable in terms of interacting through
Yeah.
the whole process. And then that decides, and so they may get it wrong, they may get it right, but that's what you have to do if you don't
You made
consent.
a very important comment about being reasonable, because it's in your client's interest to be reasonable even when the other side's not being reasonable, because that reasonableness can be used to their benefit when you're presenting your case to the court if it has to go that route,
Right.
And used to their, hopefully the judge looks at the fact that one party's being reasonable and is more considerate of their needs because of their willingness to be reasonable. That's what it sounds like.
Oh, definitely. I think it also comes down to one of two things happens when you're being reasonable. One, the other side starts being reasonable and everything just kind of works out.
Clicks together. Mhm.
Or you got an order and now it's going to benefit you in the court.
And I think it's important to note that oftentimes when the judge has to have a trial and make the decision, one party's going to be unhappy, usually.
Oh, definitely.
It's then we're having to say, instead of you guys agreeing and coming up with a solution that you both can live with, one party might be very happy with that decision and the other party is going to be very unhappy with that decision. Right?
Oh, yeah, most of the time there's usually really one unhappy person. Usually when there's a consent, everybody kind of walks away and goes, I can live with that. But when it's the judge deciding, somebody usually storms out of the room upset and frustrated.
So let's talk about high conflict cases. So, we've been talking about just regular cases where parties can't get along, but there's other cases that take it to another level, I guess, the high conflict custody cases.
When it's high conflict, it really comes down to, what we provide in terms of service as attorneys in general is you've got to have the evidence. You've got to produce different documents and stuff, and you got to focus on those things, because if court sees two people just yelling at each other and calling each other names, they're going to ignore both of them and just do what they think's best. You got to really kind of bring that part back, be kind and considerate, even when you don't feel like it, right? Again, actions over feelings. And then that'll help you put together an argument that the facts demonstrate what's going on, not the emotions.
Right, and in the high conflict cases, aren't judges often ordering psychological evaluations and making all other kinds of professionals come into the case, which of course is costing everybody more money, causing more delay?
Oh, definitely, and there are times where there's need for that, when there are true facts demonstrating one parent is having a struggle with some kind of substance or gambling or something like that. But sometimes it's just because it's so conflict and they can't decide, they have to bring in experts. Experts take time, experts take money, and delay the whole process. The process that's taking about a year now could become a process that takes 2 years. Mm-hmm. And nobody wants that uncertainty, especially when their children are only with them for 18 years of their life.
Right. And during this whole process, where are the kids? Is there some sort of temporary order in place that tells the parents what happens while they're waiting for this long court process to finish?
Oh, yes, definitely. The court always puts in some kind of temporary pending order early on, as fast as they can. Sometimes that's not super fast, but everybody wants that quickly. That usually takes about 4 to 6 weeks to really get that finalized and worked out. But there will be a temporary plan in place, but that could just cause more and more problems. The sooner you can get to a final plan is always best.
Right.
So,
well, thank you for these insights. Very helpful.
Thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
The recent changes to our auto insurance laws impact everyone in the state of Michigan. But senior citizens are one group of people that have unique circumstances that affect them differently with the new auto laws. Today we have Steve Sinas, a personal injury attorney at the Sinas Dramis law firm, here to help us explain how the new auto insurance laws affect senior citizens.
Thanks for having me.
You're welcome. So Steve, tell us about what some unique concerns there are for senior citizens when they have an auto accident.
So I've had a good amount of experience representing seniors who are injured in car crashes. And their bodies just recover differently from injury. Sometimes it can lead to decline. There are just some special considerations that play into how they recover from their injuries. They also have fixed incomes, which affect their ability to take on their cost of treatment if they have to pay out of pocket. And if they're ever facing any type of financial liability from a car crash, if they make a mistake, they certainly don't want to have to pay out of pocket in the event that they've hurt somebody else. So they have some real special considerations, and that's why we're here to talk about that today.
So help us understand how it worked under the original no-fault law for senior citizens who had an accident.
So I'm going to try to make this simple. Under the original no-fault law, everybody had to buy no-fault medical expense coverage with lifetime coverage. It didn't have any monetary caps. So if you were a senior and you're injured in a car crash and you're entitled to no-fault benefits, your care and treatment would be covered for life. You didn't need to turn to Medicare or other sources of insurance. And no-fault insurance coverage was there to pay your medical expenses in full, so you wouldn't have to pay for your co-pays and deductibles. So for seniors, it resulted in this comprehensive care. The one thing for seniors, though, is that it would be costly to buy no-fault insurance because they couldn't coordinate. They couldn't buy the cheaper option that was available for a lot of people where they could elevate their health insurance to be primary, because seniors are on Medicare, and the federal government does not allow you to coordinate with other coverages to make Medicare primary. So seniors always had to buy uncoordinated no-fault, which was costly for them, but they still had comprehensive coverage under the system.
And lifetime benefits.
Yes.
Right. Okay, so how did the 2019 reforms change that for senior citizens?
So there's so many things to talk about with the 2019 reforms, but with regard to seniors and their insurance buying decisions, they now don't have to buy lifetime coverage. They can buy capped no-fault medical expense coverage, and they also can opt out from no-fault insurance coverage altogether. The one thing, though, that the reforms didn't solve for these group of people is that with regard to their ability to coordinate, they still can't coordinate to make Medicare pay primary. There could have been creative ways the legislature dealt with that issue and gave them a right to make it so that they got some type of credit or reduction in their premium because they had this other source of coverage through Medicare. But they didn't do that, and so now these people have to either cap their coverage, they can still buy lifetime, or they can opt out altogether. But there's some real concerns about that opt-out.
Well, let's talk a little bit more about the opt-out option and what is the problem for seniors relying on Medicare for their auto accident care and treatment.
Yeah, so when you're buying auto insurance, if you're a senior citizen and you're on Medicare, you're going to be given this option where you can just basically opt out of no-fault medical expense coverage altogether, which means that if you're injured in a car crash while occupying a vehicle, doesn't matter whose vehicle it is, you're not going to have any no-fault medical expense coverage. And with regard to the issue there, Medicare does not provide for comprehensive coverage if you were severely injured in an auto accident. It may pay for your frontline medical care, your surgeries, your hospitalization, but it doesn't cover long-term care, long-term residential treatment, supportive services such as guardianship services, case management services. And I've represented a lot of senior citizens, and they need these types of services and accommodations.
And those things are provided by the no-fault law.
That's right.
Got it. Okay.
So when you opt out, you're saying, you might be thinking to yourself, well, I'm going to just turn to Medicare and it's going to be okay. But the reality is, if you do that, you might very well have to pay a lot of money out of pocket if you're severely injured. Whereas if you had lifetime medical through no fault, you wouldn't.
So for the seniors who do opt out of the no-fault medical expense coverage, what are their rights and benefits if they are injured in a crash?
Yeah, as I said before, if you opt out and you're occupying a motor vehicle, you really have no right to turn to the no-fault insurance system to cover your medical care and treatment. So people just need to understand that. There is this aspect to the law that if you are an opt-out or you're hit as a pedestrian, you can cover your medical expense coverage up to $250,000 through the assigned claims facility, which is this unique entity under the no-fault system. But for all other situations for opt-outers, if you're in a vehicle, you have no-fault rights, and you're going to have to pursue other sources of recovery for your care and treatment expenses.
Okay. And do seniors with the limited no-fault medical expense coverage have a right to recover the payment of their medical expenses through any other source?
Yes. So if you have limits on your no-fault medical expense coverage, or you are opting out of your no-fault medical expense coverage, you can pursue your medical expenses from the at-fault driver in what is known as an auto negligence claim. And an auto negligence claim is brought against the at-fault driver, but there are some practical limitations in terms of that being a real source of recovery for these senior citizens.
Okay, and tell us more about what those limitations are for with pursuing an at-fault driver.
Yes,
right,
with
okay.
Pursuing an at-fault driver, what you're dealing with in terms of a practical limitation at first is the fact that you have limits on your liability insurance coverage that applies to that at-fault driver. Those limits might be somewhat significant or they might be minimal. And so when you're pursuing the at-fault driver, you have to understand that it's not an endless amount of money that can be recovered there. They have their own limits on their policies. The other issue is that for these senior citizens on Medicare, when they make a recovery against the at-fault driver, the federal government has a right to come in and claim a lien on the cost of the medical expenses that the government paid for that senior's care related to the auto accident. And so the senior who thinks they might be getting some money as compensation for their pain and suffering, all of a sudden realizes that the government can take back its money and there's nothing left.
Because of the medical expenses being so much.
Right. So it's another reason to be real cautious about opting out of your no-fault insurance coverage.
Okay. So, with the time we have left, I think we should, if you could tell us what your ultimate recommendation is for senior citizens who are in the process of buying their no-fault insurance coverage. What are your recommendations to help them make good buying decisions?
So I want to first say that I regret that my recommendations are probably not going to result in a reduction in the cost of people's insurance, but my recommendations are based on what I believe best protects people. And if I was making a recommendation to a family member who is a senior citizen, I would say continue to buy lifetime no-fault medical expense coverage, even though it may be expensive. And also, look at your liability insurance coverage in the event you make a mistake, because the other aspect of this whole system is now we can sue each other for our uncovered medical expenses. So if a senior was in a situation where they hurt somebody else, there can be a lawsuit brought against them. And when it comes down to it, the senior might have their own financial liability there. So they want to make sure that they have high liability insurance coverage. And the other way they can protect themselves is through what is known as uninsured or underinsured motorist coverage. And that's in the event the senior is hit by somebody who doesn't have insurance. And if they buy that coverage for themselves, their insurance company steps in the shoes of the at-fault party and pays the claim as if they were the insurance company for that party who might not have insurance. That would be an uninsured claim, or not enough insurance, that would be an underinsured claim. So lifetime medical, increase your liability insurance limits, and buy as much uninsured and underinsured motorist coverage as you can.
So for seniors on a fixed income, how much more money are we talking about?
Hopefully not too much. It depends on where you live. And that's the one thing about these reforms. They're saying that it's going to reduce the cost of our auto insurance, but to have the coverage you need to protect yourself, it may actually cause you to increase the cost of your auto insurance.
All right. Thank you, Steve.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for joining us on In the Name of the Law. We look forward to seeing you next week. In the meantime, I wanted to let you know about a book I just published called Kids Caught in the Middle: How Families Are Harmed When Judges Don't Follow the Law. The book is designed to shine a light on the problems that can come up in family law cases, and you as a parent can look at the book to get information to help you understand how the process works. You can buy the book on Amazon.com or BarnesandNoble.com, or get more information by going to my website, LiisaSpeaker.com. See you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.